All right, guys, we are going to continue with our discussion of the judiciary, taking a look at the layout and the makeup of our court system. So this graphic is giving you from the highest court to the lowest court, but you'll also see that most courts, so like the pyramid structure here, the most courts that we have in our system are these district courts. So they're the lowest level. If you have a case that goes to a federal court, it is going to start most likely in the district court. They'll have original jurisdiction for most cases, which means that it's the trial court. It's where you would present your evidence and you would have a jury potentially making the decisions. We have 94 different district courts. All 50 states have at least one district court. And again, the district courts only have original jurisdiction, so that's where the trial happens. Sometimes you'll hear the district courts referred to as those trial courts. Then you move up and we have got the Court of Appeals. So the appellate court is the system that is the middle system. And this is where, especially if you've got a situation and a decision that was made at a district court level, you're not happy with that decision, you can appeal to the appellate court. And depending upon where you live, will then determine which appellate court would hear that appeal. Iowa, for example, as we'll see on the map, is part of the 8th Circuit Appellate Court System. Appellate courts do not have original jurisdiction. They are not going to retry the case. Instead, they will review what happened during the trial, and they'll review precedent, and they will see if there's a reason that maybe the law was not followed appropriately, or there were problems with how the trial itself actually took place. And if they think that there's enough reason, they will actually remand the case back to the district court for potentially a retrial. Otherwise, they might uphold the trial court's decision and basically say, we understand you're not happy, but there isn't a reason to have a new trial. This decision was reached appropriately and it will stand. And in that case, you have the choice. You can try to appeal it to the Supreme Court, but the Supreme Court does not have to take your case. So when you're taking a look at the number of cases that the Supreme Court will hear in a year, typically it's below 100. They have been hearing more cases, but we typically see, a little less than 100 as the norm. The Supreme Court does have some limited original jurisdiction, and we'll talk about that in a little bit further. There's a graphic in the textbook that also goes over this. But over 90% of the cases that come to the Supreme Court are going to come through the appellate jurisdiction, the appellate process. And that's when they're typically going to be looking at a significant issue either with federal law or with the Constitution and how the federal law and the Constitution are being applied in a case. So even in, for example, Obergefell v. Hodges, which was the 2015 decision about same-sex marriage, the decision was not just about same-sex marriage. It wasn't pinpointing just that specific issue. It was actually taking a look at the 14th Amendment and the equal protection and what that means in terms of disparate legislation about marriage state by state. And do people have the right to the equal protection of the law when it comes to marriage, for example? Okay, so here's that map that I was talking about, and this actually shows you the district court. So you can see the district court boundaries here, and then the circuit boundaries. So Iowa is part of the 8th Circuit of Appeals, but then you'll also see that Iowa has 2 federal district courts, the northern and the southern, versus Minnesota and the Dakotas, Nebraska, they all just have 1. And the decision to create new district courts frequently happens when they're looking at caseload, not necessarily just by population. Okay, this is a graphic from your textbook that's also really, really helpful because it's going to tell you that it's showing you the dual court system. Now, we're not necessarily getting in and talking about each individual state or even how Iowa works, but most state courts follow this three-tier system as well. So in Iowa, we do have our state trial courts. They're typically at that county level, so the Johnson County court system, for example. And then appeals courts and the Iowa Supreme Court. So typically you see this happening. Again, the lion's share of the cases that happen in this country, you can see here, happen in the state courts and happen in those state trial courts. 100 million filings per year versus 350,000 cases per year. But federal court system is going to go in and take care of things and issues dealing with federal law. So you see it here at the top. I'm not going to move my mouse because then it cuts off the bottom of the slide there. But on the left-hand side, you see the original jurisdiction. So U.S. district courts only have original jurisdiction, and those are the types of cases that they will hear in a federal court. You'll notice that civil suits between citizens of different states, if the amount at issue is more than $75,000. So this is where typically a state court would take this civil suit, but in high cost or high dollar, it could be shoved over to the federal court. They do have original jurisdiction for that. And then you'll see coming up to the appellate courts, they have no original jurisdiction. So all of their cases are going to be heard on appeal, either from lower federal courts or from a regulatory commission, or we do have some special legislative courts. And remember from your reading that people that judges who are appointed to legislative courts actually do have term limits. That is a little bit of a difference from the constitutional courts. And then you see the Supreme Court, and again, the number of cases they hear each year is extremely limited, and we'll talk about how they choose those cases later on. But they do have limited original jurisdiction. So a state and a citizen of another state if the action is begun by the state. For example, we also see if it involves a diplomat or foreign ambassador. If the United States is the party and is making a suit to a state, or if states are suing each other. But then you'll see the appellate jurisdiction is how most of the cases arrive. Finally, you can see that the dual court system can intersect if the highest court in a state court makes a decision. People can then appeal to the U.S. Supreme Court to hear their case. They're not going to take a ton of these cases, but it does happen. Okay, this actually goes again back over some of the district appellate and Supreme Court parameters. And again, I want you to be aware this key term here, diversity case or diversity jurisdiction. This is dealing with cases between states or citizens of different states. And again, typically you will see, especially in those high dollar cases, that district federal courts will take those on. And then courts of appeal, stare decisis is something that you should be familiar with, as well as brief. So creating a brief for a case in order, like laying out the reasons that they are appealing their case and why they think a decision should be changed. Stare decisis is basically the general expectation. Let the decision stand. So appeals courts are not going in with the notion that they need to overturn the district courts. They want to have good specific reason to overturn or remand a case back to a district court. Stare decisis is let the decision stand. So if there's not enough reason to remand the case or overturn that decision, then they won't do that. And then the Supreme Court, we're looking at a 9-judge panel here. And again, they're also going to frequently follow stare decisis. So if there's not enough reason for them to take a case on, number one, they're not going to. If it's not significant enough, it's going to go into the round filing bin and not be seen again, at least unless someone tries to bring it back to their attention. The other thing is that the Supreme Court is not necessarily looking to constantly overturn previous precedent. So they're going to look at past precedent and they're going to really try and decide if there is enough reason, if the previous courts were wrong, if they've already ruled in an issue, or if it's a significant enough constitutional question that has not received a ruling that they should weigh it in. One of the things that we're seeing this session is that the Supreme Court is willing to weigh into gerrymandering from a partisan perspective more than they have in the past. They've weighed in on gerrymandering, but they've always avoided the partisan question. And we see that they've taken on some cases that could change that. And that leads us again, so original and appellate jurisdiction. Hopefully now you have a clear understanding of these terms. Original jurisdiction is the ability and the authority to hear a case at the trial level. So they're hearing all of the evidence and they're making decisions as to guilty or not guilty in a criminal case, or fault and the degree of fault or no fault in civil cases. That's where your Law and Order shows and all of those dramas that you see, those are trial court's original jurisdiction, where the facts of the case are being laid out. Appellate courts are the appeals process, where you're appealing to a court to take a look at what happened during that original case, and you're asking them to come to a different decision. A lot of times, the people who appeal would like the decision to be outright overturned. So there's enough evidence to show not only was enough done wrong, but the other conclusion should have been reached pretty easily, overturning the decision, or remanding the case. That there was enough done and enough inconsistency with the trial that they are taking the case and they're sending it back to the district court and saying, you need to retry this. There needs to be a new trial. Or upholding the decision. So looking at everything and saying, no, there's not enough reason to have a new trial and there's nothing to show that it should be overturned. We're upholding the original decision. Appellate courts are not going to be, they're going to be done with a bench with usually about 3 judges and justices, or judges on the bench. It could be more sometimes depending upon the case. And this is not where you're going to have all of those facts retried with witnesses and such. Okay. The organization, again, of the federal court system, looking at criminal and civil law. So we just took a look at the state and the federal system, and now taking a look at criminal versus civil law. So some of the things, the plaintiffs, the defendants, the judges, and the juries, and how this kind of plays out in our criminal and civil law system. I think I'm going to go ahead and stop this one here and pick this one up in a different video.